Good morning, everyone, and welcome back to Coffee with Craig, where we talk about all things firearms, firearms policy, politics, culture, media, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program so that your friends can know where the conversation is taking place. Also, if you haven't already done so, make sure you subscribe to our YouTube channel. Follow us on Facebook, Instagram, and Twitter. And in the case of YouTube and Facebook, make sure you hit that notification button. That way you'll be notified as soon as we go live, and you can participate in the live chat as the program is taking place. Also want to encourage you, please visit fpcgear.com. That's fpcgear.com. It is the place to go to find all of your Pro 2A swag. I'm talking T-shirts, I'm talking coffee mugs, I'm talking hoodies, tank tops, stuff for the significant other, stuff for the office, or stuff for the home. Or let's say you want to go out and you're in a place that requires a mask. Well, we got that for you too. Now the best part about it is that you can, every dollar that you spend goes right back into the fight for a right to keep and bear arms. So you can support the Second Amendment and you can look good doing it. That's fpcgear.com. All right, folks. So today we're going to talk about, something that is highly frustrating as we see it, as many of us see it in states like California, where, the right to bear arms outside of the home isn't necessarily seen as a right. For those who live in the Ninth Circuit, in many cases, especially for example the state of California, you don't know exactly what the right to bear arms outside. You don't even know exactly what that means, and that's largely because in places like California, your ability to carry a firearm is at the discretion of local law enforcement, of the county sheriff or of the local police chief. They get to decide whether or not you get to be able to get a concealed carry permit, because in the state of California in particular, there is no open carry. So you're not allowed to open carry, and you may or may not get a chance to exercise to conceal carry. That's resulted in counties where you have, in some cases, you have only a handful of people have concealed carry permits, and you have some counties where they're issuing them by the thousands. Now, one county in particular that is very restrictive of their concealed carry permits is Santa Clara County in the state of California. And there is a bit of a scandal that is going on there regarding bribery, regarding concealed carry permits, and campaign contributions. In fact, here's a quick story, and it'll kind of tell you a little bit about what's going on. And then we're going to have on a special guest who's going to hopefully help give us a little bit more detail about how this overall impacts the rights of those throughout the state of California, but also especially there in Santa Clara County. So here it is. Check out the story real quick.
Santa Clara County's top prosecutor is vowing to identify and charge more suspects in a bribery scandal just uncovered at the sheriff's office. KPIX5's Maria Medina explains a well-known sheriff's captain faces prison time if found guilty.
We are not done.
Today, District Attorney Jeff Rosen promised more suspects would be revealed in a bribery case involving concealed carry weapon permits and a campaign donation to Sheriff Lori Smith.
I expect more charges will be filed against more individuals in the coming weeks.
For now, the more than one-year investigation uncovered 4 suspects, including Sheriff's Captain James Jensen, a former spokesperson for the department.
If you are, in the words of Sheriff's Captain James Jensen, a VIP, then he'll meet you at Starbucks, personally review your application, and help you fill it out.
Jensen allegedly agreed to falsify information to get the sheriff to approve about a dozen hard-to-get CCW permits for protection agents and an international security company in 2018. In exchange, the company manager agreed to give a $90,000 campaign donation for Sheriff Smith's re-election campaign that year.
But there are some real victims here too, okay? And they are people like my client, Tom Skoka, who did not get a permit.
Attorney Donald Kilmer represented a Santa Clara County man who owned a private security company. He sued Smith for repeatedly denying his CCW application. Kilmer says the state law that gives sheriffs and police chiefs the power to approve or reject CCW applications is the problem.
Our lawsuit was a straight up public interest lawsuit to try and force the government to explain why some people get permits and why some people don't get permits.
The DA says what they uncovered were two paths for CCWs in Santa Clara County.
If you were an average person, it just got thrown in the garbage. But if you made a campaign donation and if Captain Jensen, knew you to be a VIP, then you got special treatment and you got a CCW license.
So, Maria, did the district attorney give any indication that the sheriff knew about this? The donation was going to her reelection campaign.
And Juliet, we asked the DA that question several times. All he would tell us is that there would be more charges against more people in the upcoming weeks and months. We also asked to speak to the sheriff, but the spokesperson only told us that Jensen is on paid leave.
All right, we'll continue to follow this. All right, Maria, thank you.
All right, and so with us we have Don Kilmer, who's done a lot of work with the Firearms Policy Coalition, the Firearms Policy Foundation, as well as the California Gun Rights Foundation. Mr. Kilmer, how are you doing today?
Doing well, thank you. Thank you for having me.
Excellent, excellent. So you're pretty familiar with Santa Clara County and their concealed carry program, are you not?
I'm familiar with it directly because we did some litigation in Santa Clara County, but I'm also familiar with it from a general standpoint because I was on the team of lawyers. Alan Gura was lead counsel. I was on the team of lawyers that challenged the discretionary carry policy of sheriffs.
So do me a favor and tell folks a little bit about the case that you worked on and how it kind of intertwines in particular with this particular story.
Okay, well, the first of all, the general overall scheme is that California doesn't necessarily restrict your right to keep and bear arms outside of the home by its statutes. What it does is it vests, as you stated in your intro, it vests the power to issue carry permits or concealed carry permits with sheriffs and chiefs of police. Now that's for concealed carry. Open carry, if it's related to work, for instance, if you're a security guard or you're working in a security type business, you can get a permit from the state of California, but it's not. It's a statewide permit, but it's issued through, I believe, the Department of Consumer Affairs, and it's a permit for open carry. Now, that's important because that's part of the lawsuit that we filed in Santa Clara County. The overall scheme in California is that sheriffs and chiefs of police can issue to anybody a concealed carry permit to anybody who the sheriff or the chief of police, in their own personal discretion, believes has good cause to carry a firearm concealed in public, and who also has good moral character. Now, the good moral character is pretty straightforward, although it hasn't actually directly been challenged in any of the courts yet. But it's basically assumed that good moral character means that you don't have a police record, you don't have arrests or convictions for crimes of moral turpitude, which are crimes that involve dishonesty or stealth or attempt to hide things from the government. The problem was always the good cause. Most sheriffs took good cause to mean, well, somebody's out to get you, or somebody's out to hurt you, or you've got a stalker, maybe an ex-boyfriend or an ex-lover, or a business relationship that's gone bad. Of course, the problem with that logic is if somebody is stalking you and harassing you and disturbing your peace, they should be in jail for those crimes, okay, rather than actually harming you. But notwithstanding that, the sheriffs looked for some elevated cause or elevated good cause. Our lawsuit initially back in 2010, 2011, and eventually got decided and consolidated with a case called Peruta. Our case was to say that sheriffs were required to interpret good cause as just the language of the Second Amendment. That my good cause is I have a right to self-defense, and it doesn't stop at my doorstep. So that was the gist of the overall case that we filed. And then there was a companion case, or what we call a trailer case, that was called Skoka versus Santa Clara County and Sheriff Smith. Now, in that case, my client was a person, Mr. Skoka, who had a security business. It was involved in executive security and what have you. Well, he wanted to get a concealed carry permit because a lot of his clients, who were high-profile businessmen, don't really want a security guard tagging behind them with an exposed gun. I mean, in business meetings and in public settings, you don't necessarily want it to look like, you've got some guy with a gun following you around.
That only makes sense.
Yeah.
One would think,
So he
yeah.
applied for a concealed carry permit so he could do his job and protect these executives. And he had already obtained and was using an open carry permit from the state of California. So we thought this would be a perfect case as a follow-up to the good cause challenge, which was a constitutional case. The Skoka case was more along the lines of equal protection. And the argument was going to be, it makes absolutely no rational sense whatsoever for Mr. Skoka to be armed in public with an exposed gun and say that he somehow either lacks good moral character or lacks good cause to carry a gun hidden or concealed. Well, the problem with the case was that the Ninth Circuit, even though we had an initial victory in the Peruta/Richards case, I was involved in Richards versus Yolo County,
Right.
which was actually filed first, and the Peruta case kind of came along behind us.
Right.
But then it got priority, so everybody got consolidated with Peruta.
Mm-hmm.
We initially won. We thought, great, then we'll win in Skoka too. And then, and the purpose of the two-step lawsuit was to make sure that sheriffs couldn't wiggle out of the good cause requirement of the Second Amendment by saying, well, if you can carry open or carry concealed, or the argument would go, if you can carry open, then you can't carry concealed, and vice versa. So we were trying to basically block that loophole with some basically anticipatory litigation. Well, if the folks who watch your show have been paying attention, we initially won Peruta. It looked like we were going to get shall issue carry in California, but then a Ninth Circuit panel took the case and reversed it, and then the U.S. Supreme Court declined review in the case, with a dissent, by the way, from Justice Scalia when he was still alive, and
Right.
Justice Thomas, who still sits on the bench. So once Peruta went down in flames, the Skoka case also went down in flames. We didn't get an opportunity to conduct any discovery. That was a secondary thrust of the lawsuit, was not only were we going to sew up any equal protection issues, we were also going to get discovery to show that some of these sheriffs engage in something that looks like, okay, and in government, when we're looking at our government, the appearance of impropriety is something that should be avoided as well.
Right.
I'm not sitting here saying that Sheriff Smith was engaged in a quid pro quo of X number of dollars for X number of CCW permits. She may very well have, been doing her due diligence. Maybe she's restrictive of the right to keep and bear arms in public, but the whole point of the lawsuit was to take that discretion away from her,
Right.
and say you must abide by the Second Amendment and allow people to exercise the right to keep and bear arms in public. Your only discretion is to do a background check and make sure they're a law-abiding citizen, make sure they're a person of good moral character, and make sure that they have some minimal or threshold level of training, so that they're carrying and using firearms in a safe and lawful manner. But that gets stretched into, well, I can decide whether or not your life is really worth protecting, and that's what we objected to.
All right, so then along comes this particular story, this particular case, and what's going on, and I think you made a really good point. Part of the challenge was this probably, if that case had gone forward and you had the opportunity to do the discovery, this probably would have come out much, much earlier.
Yes, I believe that it would have.
And unfortunately,
So by the way, this is a great example, by the way, of how when courts ignore fundamental constitutional rights, like the right to keep and bear arms, they don't allow equal protection lawsuits to go forward, they end up they allow the government to cover up its mistakes.
Right.
Okay? It's the same thing we see, for instance, in the controversy over unjustified police shootings and qualified immunity. Okay? Qualified immunity is not constitutionally authorized. It is a creature of statute, of judicial invention, and it is a legal doctrine that stops discovery and stops the lawsuits. Some of them, in my opinion, that are legitimate from going forward by saying that police officers who don't have, controlling legal authority are authorized to act unless they're told what they're doing is illegal. And we see how qualified immunity has completely corrupted, the ability for plaintiffs to sue police departments and police officers for bad conduct. So we had the same thing here, where when the Second Amendment was trashed, we were not allowed to move forward on a case that would have exposed all of the things that came out in this Santa Clara County controversy. Okay. Now the grand jury, of course, doesn't have to have a plaintiff. It doesn't have to have a constitutional theory. The grand jury can just say, "Hey, we're going to take a look at this," and they did, and they found the evidence that we would have also uncovered in discovery, and now they've moved forward in with grand jury work and apparently indictments in Santa Clara County, and the sheriff taking the fifth on several occasions in her testimony. So it just doesn't look good.
No,
again, and even if we assume Sheriff Smith did not tell her underlings to, I'll trade permits for cash for my campaign. We don't know that she said that. Maybe she did, maybe she didn't. That's for a jury to decide. But we shouldn't have a system where the government gets to dole out your right to your ability to exercise a fundamental right. We already know, because of the way we have our Constitution set up, that rights aren't negotiable. Whether the sheriff issues you a permit or not, you have a right to defend yourself in public. The problem you're going to face defending yourself in public is whether or not you get arrested before while you're carrying, before the event happens. And this is what's so insane, by the way, about the discretionary issue policy. Well, we'll only issue a permit if you can prove that somebody's chasing you or somebody's trying to hurt you. Well, how the hell do I know that? Okay. We've seen recent acts of violence in the streets of some of our major cities, in Portland and Kenosha and Seattle and many other cities throughout the country, where they're random acts of violence. Somebody is picked on or somebody is targeted because of the color of their skin, white or black. That shouldn't be happening.
Right. No, and it's especially especially in these times right now, where literally, and I'll give you an example. My wife and I had taken our granddaughter. We went to a park that was on the river, that was on the other side of the city of Sacramento, and we were on our way back. And the good thing was we went back home when we did, because if we had been just 5 minutes later, our car would have been surrounded and would have been surrounded by protesters in Sacramento. And I'm sorry, but that would have put me, my wife, and my granddaughter at risk. I mean, my right to defend myself and my family and my property doesn't end at my front door.
No, it's
not. And in my home, it's not discretionary. It shouldn't be discretionary when I'm out, when I'm away from home.
And here's the fallacy of saying, well, that's what we have police for. Okay, the Supreme Court has ruled on many occasions. The lead case is DeShaney versus Winnebago County. The police do not have a duty to protect you in public. Okay, the only time that duty arises is if you are in the custody of the police, or you are otherwise disabled from exercising your own right to self-defense by the police. So at the same time that the Supreme Court says the police do not have a duty to protect your life, and then that's out of one side of their mouth. On the other side of their mouth, the police are saying, "And we're not going to let you carry a gun to protect yourself."
So here, let me ask you a quick follow-up. So that last part you said, where if they have removed your ability to defend yourself, I'm assuming that law enforcement telling you cannot conceal carry, that doesn't count as them removing your ability to be able to defend yourself.
Unfortunately not. The classic case on where the government puts you in a worse position, where the duty to protect does arise, would be, for example, if the police pick you up and transport you. The classic case was the police picked up some guy on a off ramp of a freeway or something. I'm trying to remember the facts right. And then they just drove him down the road and left him on the side of the freeway again. And he ended up getting hit by a car. And so he tried to sue. And the argument was, well, the police don't have a duty to protect. Yeah, but the police put him on the freeway. Okay. And that's where he got hit. So in that case, yeah, you can bypass the police don't have a duty to protect. But for the most part, the facts of the DeShaney case are just horrible. And there are other follow-up cases where literally somebody calls 911 because somebody's trying to break into their front door. The police cruise by the house. They don't get out and investigate. They don't walk up to the house and see, hey, what's going on? And by the way, inside the rape or the murder is occurring. And people try to sue and say, well, your police cruiser you drove by the front after we called 911, and then you didn't come in and find out what was going on. Well, police are not liable because there's no duty to protect. So even in your home, the police don't have a duty to protect you. So the idea that you are restricted to carrying a gun or having a firearm only in your home, which is the current Ninth Circuit state of the law, and therefore can't defend yourself outside, well, I don't know. Maybe I don't know how to tie this into COVID-19 since none of us are allowed outside anymore.
Well, and then you add on top of all that, you add in instances or cases like this where there seems to be basically a pay for play.
Yeah.
And,
it looks bad.
I get that there are some law enforcement officers who just believe that, individual citizens shouldn't have guns. I don't agree with it, but I get that. But my next biggest issue is that people want to profit from allowing you to exercise that right. They want to hold that right hostage so that they can personally profit. That is a next level of tyranny that unfortunately we've allowed ourselves in states like California to be subjected to.
That's just straight up graft if that is what is happening. I mean, here, Sheriff Smith's best defense, not that I'm necessarily interested in helping her out, but Sheriff Smith's best defense is going to be, of course, I only gave permits to people who donated to my campaign. They were people who knew me, people who I socialized with, people who I had a good established relationship with, who I felt that I could trust. Now, that's sort of doesn't pass the smell test, and is sort of, again, sounds like a pretext. Yeah. But that's probably her best defense at this point, is to say, no, it wasn't. Yeah. I didn't do it for the cash. I did it because I know these guys, and these guys know me, and that's why they wanted me to be sheriff. They donated to my campaign. Now, whether that flies with a jury or not is going to be, that's what's going to have to. That's what juries are for. But you can see where even an innocent sheriff. And Sheriff Smith's entitled to the presumption of innocence in a court of law, although not in public opinion. But even a perfectly innocent sheriff is going to say, either your point earlier, just don't issue to anybody. Okay, right. That's the safest thing. Or if I do issue, make sure I issue to somebody who I know is not going to abuse it, which means I'm going to issue to other people in private security business or former police officers and sheriffs. Or people who I socialize with, and people who give me money to run for sheriff.
And there you go.
It doesn't look right.
No, it doesn't.
It smells to high heaven, which is why shall issue is the only constitutionally valid policy.
Well, and if you look in counties that do pretty much act as shall issue, their murder rate, their use of firearms in crimes, their rate is not any higher than in counties that have very restrictive concealed carry policies.
Right.
But they don't talk about that. They don't want to talk. They want to say, well, more guns is going to equal more gun violence. And that, unfortunately, legal gun owners, that has just not been the case. This never proven to be the case. But unfortunately, those are statistics that they're not interested in necessarily sharing.
Well, I mean, the statistical arguments are worthy of listening to, and they obviously need to be, studied and taken into account. But we already made this calculus, and I'm paraphrasing Justice Scalia from Heller here. We already made this calculus 230 years ago, and that is that we're going to live in a republic where the government is not afraid to trust its citizens to be armed. Okay, that's just the way it is. Okay, and that law and order, and that the source of law and order is the people. Doesn't come from on high. Doesn't come from our leaders, whether they're elected or they sit by divine right of kings, or whether we use a Ouija board to figure them out. Okay, are the source of law and government power is us. Okay, which is why the right to keep and bear arms cannot be cut off from us.
Exactly.
Okay, because when push comes to shove, okay, when people stop being reasonable and they start using force to harm their neighbor or to take their neighbor's stuff or to try and push political change through violence, there have to be people that can stop them and that have the tools to stop them. That's why the Second Amendment is part of our constitutional heritage. It's part of the DNA of the American Republic.
Well, and the challenge is, though, and this is where they always come at. The problem is that those who want to change the DNA of America, that's where the problem comes in, and they realize that one of the first things
it won't be America. It won't be America anymore.
Well, that's the thing. They seem to think that they can create this utopia. What they don't understand is that as you pull away at the foundational threads, you wind up destroying the entire tapestry. And that's why that fundamental right to keep and bear arms is so important, because in my opinion, it's not just a right. With every right comes a responsibility. And that responsibility, we have a responsibility to defend ourselves, defend our neighbors, defend our family, and defend our property. And I think as we take that away, as we give the government the ability to take other of our fundamental rights away.
Yeah. Well, I mean, the philosophic battleground for the Second Amendment is fundamentally an argument or a battle or a contest between people who believe in some sort of legal positivist philosophy that, well, the law is whatever the lawmaker says it is. Okay. Or what the Constitution was actually founded on, and what the nation was founded on, is this concept of natural rights or fundamental rights. That no, you have rights, certain rights. We don't know what all of them are, okay? But you have fundamental rights that exist by nature of the fact that you're a rational being, okay? That you live and breathe in the real world, that you walk and talk and have to be able to produce goods and trade with your fellow man in order to sustain your life. And that we don't want people to use force to obtain the goods and services they need to sustain their lives. We want them to trade with each other. So the purpose of government, and this is where we get, the majestic language of the Declaration of Independence, and you can see it in threads throughout the Constitution, that the purpose of government is to make sure that we can live in peace and that we live as traders and tradesmen, and that we're trading our services and products with our fellow man. We don't want violence, okay? But we do understand that there are bad people, and that when bad people are going to break the rules of civil society, somebody needs to be there to stop them, and they need the most efficient tools they can do it with. And that includes, and since if you believe that the lawmakers in the United States of America are the people, well, then the lawmakers have to be the law enforcers.
Exactly. Well, sir, I very much appreciate the conversation today. How can folks get a hold of you if they want to get a hold of you to, just kind of follow the work that you're doing, or maybe they need some legal advice?
Well, you can go to my website right now, which is Unfortunately, it's not been revamped since I've recently moved my office. I still practice law in California. I still do cases in California and in federal court in California. However, I've actually relocated my office and my home to Idaho, um, and not just for the gun issue, but there's a lot of good hunting and fishing up here too. But you can go to the website. There are phone numbers there to get a hold of me. Look for a new and improved, updated website that will have a list of the cases that my office is currently working on, hopefully in the next 60 to 90 days.
Excellent, sir. Thank you so very much. I appreciate you coming on the show, and I appreciate all the work that you do.
Greg, it's always a pleasure talking to you, my friend.
Okay, sir. Ladies and gentlemen, Mr. Don Kilmer. All right, folks. Well, hey, that's going to be it for today's Coffee with Craig. We very much appreciate you tuning in. We appreciate you liking and sharing the program and telling your friends about the Firearms Policy Coalition. We are the home in the fight for civil rights. Got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.